Good afternoon. This is Marilyn Duke, Chair of the Village of Glendale Laws and Claims Committee. And with me is Alan.
Yeah, Alan Howeller, Chairman of the Police Committee. This is a joint meeting between the two committees.
And this afternoon, we'll need to establish a quorum after we hear from David. David, are you there?
I'm
Can you hear? Great. David, can you, before we establish a quorum, can you comment briefly on the public notice that was provided for this meeting?
Yes, public notice was published well in advance of the 24-hour requirement for this meeting, posted on the village bulletin boards, through the village email newsletter, and on the village website.
Okay, thank you. I see Councilwoman Nancy Masinko. Here. And Councilman Member Will Kreidler
Here.
of the Laws Committee. We have a quorum. Alan?
I see Maryland, you are on our committee, and so is Nancy. And they're here, so we have a quorum for that meeting also.
Thank you. We need to adopt the minutes from these previous committee meetings. Is there a motion from the Laws Committee member to adopt the minutes of March 24th?
So moved.
Is there a second?
Second.
All in favor, aye.
Aye.
None opposed. Thank you. Alan?
Adoption of the Police Committee meeting of December 2nd of 2020, and these have been previously published.
And he is saying December 7th, correct?
Right.
December 7th.
So moved.
Marilyn moved.
Second.
Okay, anybody opposed? All in favor?
Aye.
Aye.
Thank you.
We are now open for public comment. And first, let me call upon David to see if any residents or if anyone is online to speak in this meeting. I cannot tell.
I do not have any public speakers that have registered through Zoom who are in attendance.
Okay, thank you. We have 3 residents here, so let me invite them to speak. And since we have only 3, the floor is yours. There is no clock or timer. I think we can move through the meeting and hear your comments. I would ask that you step up to the podium, state your name, the street you live on, and give us a 1 or 2 sentence summary of the topics you'll be covering, and then proceed in depth with your comment, please. Is there someone willing to speak first?
I'll speak first. My name is Ron Vischer. I live at 829 Kingfisher in Glendale. I've got a couple or maybe even 3 topics I'd just like to address. I'm going to address what I think will be a short one first. The discussion council recently had concerning an urban forest manager. It gave me the opportunity to review the statute on responsibilities of that person or group of people. And one of the things I noticed was that under 93.11D, it talks about Dutch elm disease and other communicable diseases or insect infestations. As I was walking through Johnny Park on the corner of Glendale and Walnut, I noticed that some of the ash trees did have evidence of emerald ash borer infestation. That was reported to the last council meeting also. And I'm not sure exactly how to address that to the village. It says if you have a complaint, you're supposed to let the village administrator know about it. I gather that the village administrator has been notified at council meeting, but it also talks about penalties and stuff in which I'm supposed to notify the police department. So my question really to this group is, what's the right procedure to make sure that the park gets protected? Similarly, 93.12 talks about the eradication of poison ivy. as I looked at Johnny's Park, I found poison ivy on the land, and it talks about a penalty in 93.99, in which there are fines that are assessed if the poison ivy is not taken care of in a short order. So again, I don't know if those fines would apply to the village. That doesn't make sense to me. But I'd just like to make sure the village is aware of the need to properly handle the nuisances.
Well, thank you, Ron. And we do have the mayor here. We also have the chief of police here. So let me begin with the chief of police and then turn to the mayor in terms of the process.
Yeah, that's my
or what it
question
takes
is the process.
for someone, for a resident to notify, so to speak,
And
the village.
And really, is the expectation that the residents need to do that, or is the expectation that the Urban Forestry Board will take care of that? Or what's the expectation when village residents find nuisances that need to be addressed and it happens to be on village property?
Well, thank you. And although that particular ordinance is not before us this afternoon, the question of residents mounting a complaint and informing the police department and the village so that there is a record of that complaint is before us this afternoon. And so I would like for Chief Walsh and Mayor Lofty.
Madam
to
Chair, if I
respond.
could lead off before Chief Walsh, just
Sure.
because what I have to say is very brief. Any resident can inform the village of any violation that they, of village code or concern that they have. And the best way to do that is just to contact the village office. That would normally be our administrator, David Lumsden, who would then take the complaint and determine what the appropriate action on it is.
Police chief,
It'd be the same for us if you want to call the
I'm
police
sorry,
department.
if you could turn the mic towards me. Yes.
I'm sorry. If you would like to contact the police department or stop by the police department, we can stop by your residence. Be more than happy to take that complaint.
Let me also say, people have emails these days, especially village officials, and it's always good to have something in writing, so you can always email them and copy each other, and that way everyone presumably has notice at the same time, whether or not they actually read it.
Okay, so if a resident wants action to be taken, even though it's part of the statutes of the village, they need to really take action. We shouldn't be expecting the village to self-police, if you will. I mean, that I would desire that the village self-police.
If I may, I'd like to chime in and provide my perspective on this matter. The village takes the maintenance of its properties very seriously. So while we certainly do invite and respect when residents bring forward situations that come to their attention, we have a public works department that works diligently to maintain our public spaces and eliminate invasive plants, invasive species, pests, weeds, those sorts of things. We are unfortunately a small department, but we work quickly and diligently to get those things addressed. So if you notice something that comes to your attention that needs to be addressed, please do notify us and give us an opportunity to correct it. It's an opportunity that we take very seriously, and certainly want to get those things taken care of when they come to the attention of residents. But the village does work diligently to maintain its public space.
Okay.
Thank you. Is that your comment? Thank you. Let me ask a quick follow-up with Chief Walsh. Is there a form in the police department for residents to fill out in a written complaint?
No.
Okay.
They can, like you said, you advise they can send it through an email and we can take it that way also. If they want to send me an email, we can do that.
David, are you hearing the chief's responses?
I am.
Great, thank you, thank you. Thanks, Chief. Any other questions to Ron while he was on the floor? No? Thank you, thank you, thank you, Ron. Any other comments from the public? All right. Yes, sure.
Speaker. This, again, I don't think is on the agenda, but I wanted to raise it. It was a topic that came up in the council meeting again on Monday. And this time it deals with something that I raised at the council meeting, which was concerning the GCIC and its ordinance to sell a lot. I reviewed the laws that supported what I was saying. And Village Ordinance 32.46, which talks about the powers of the Glendale Planning and Historic Preservation Commission, states under C, whenever the GPHPC, and I'm quoting, shall have made a plan of the municipality or any portion thereof, and then there's a whole bunch of words. It says that no building shall be constructed or authorized to be constructed in the municipality or the planned portion of the municipality until and unless the location thereof shall be approved by the GPHPC. And I believe that the ordinance that went before council did not have HPC approval, or if it did have HPC approval, it was done without notification of the village residents. The implication of that is that council, by vote of not less than 2/3, shall have the power to overrule any disapproval. I note the vote was a tie that was broken by the mayor, and so that was less than 2/3, yet the mayor said that the ordinance passed. And I believe that it wasn't consistent with 32.46.
Okay, send in a written statement to that effect, and we will we'll chase it down. But did you say it's a building that they have to approve?
Well, the issue really is that the ordinance talked about more than just selling the land. It talked about selling the land for our residents. And so by having it be a plan that says we'll sell the land for our residents, as opposed to sell the land for a park or a urban forest or something like that, that gets outside what the village plan discusses as being the plan of 2000, which says we shall preserve the green space, we shall preserve trees, we shall preserve open spaces.
You do know that any building that would go up there would be approved by the GPHPC.
I don't know that a building is appropriate.
Okay. Well,
I mean, this is strictly that we need to follow the process.
Yep.
The point of my presentation on Monday was that we needed to follow the process.
I know, but
That the statute that
enforcement.
provides the GCIC, excuse me, Marilyn, I know it's way off topic.
yes, and I'll bring you back.
Could you send in the complaint, the
I will.
the
The
argument, and then
the
let's take a
question
look?
again is when a residence has a complaint about laws, what is the process that the resident
That really is the
follows?
question.
Because I'd like to keep it within council. I'd like to keep it within the community. I don't want to have to go to this, because it is violation of state law also. I don't want to have to make a big deal about it when it can be resolved in a
Just
friendly manner.
send in the
And
complaint.
no one has said who. Do I send it to Marilyn? Do I
Send it-
send it
Oh,
to the
you
mayor?
send it-
Do I
you
send
can-
it to David? Do I send it to the whole council?
You send it to David.
Okay.
Well, let me also suggest that in regards to that ordinance, you can send it to, address it to David and copy the mayor, also copy the chair of the laws committee. And I thank you for bringing it up in the laws committee. If it's a question around enforcing the existing laws, that certainly is appropriate for this committee to talk about and look into. And I don't want to ignore what you are saying this afternoon. I want to thank you for bringing these things up.
Yes.
And ask if you have any other matters to bring up before we move to the next item on the agenda. We want to encourage comments from the public. not stifle them. But at the same time, we want to try to stay on topic and refer action where appropriate elsewhere. So I appreciate Mayor Lofty and Chief Walsh for speaking up, as well as Administrator Lumsden. I'm surprised that residents such as you yourself, who've lived in Glendale this long, are not, you're not more familiar with the process. And certainly if you're not, others are not. So that's my assumption henceforth. Thank you. No comments? The next item on the agenda is the, just a quick acknowledgement that this meeting is under the Ohio Sunshine and Open Meetings Act. And there has been a lot of conversation, talk, chatter, communications in and among elected officials, in and among residents, in and among people commenting through social media. That is outside of the open meetings. If something is to be considered, it needs to be brought into an open meeting. We're not having round robin meetings or meetings before the meetings to plan the outcome in advance and many of the other things prohibited under the Open Meetings Act. But I just want to bring this out on the record here because there's been an escalation in conversations and media, social media, around junk vehicles and the way the village looks, et cetera, and it needs to be brought before a duly convened committee. That's all I'll say about that. Having said that, I'd like to ask Alan, as chair of the police committee, if you will recap
Certainly.
how this matter of looking into junk vehicles came up last summer and where we are now with it.
All righty. The police committee, the police chief at the time, Dave Werman, had some complaints about certain vehicles and junk stored in yards and wanted to know if our policy was correct and was it enforceable and was it something that a number of the residents of this community felt was important. Obviously, that was felt important. We do have some regulations. They're solely inadequate. And so what we've done is the police department and the police committee started the discussion. And at that point, we decided to look at other communities and what their junk vehicle ordinances were. And we asked our solicitor to start a type of an ordinance, a preview of an ordinance that we could discuss and find if there is merit or common ground to that ordinance. We have with us in a handout, and I don't know how you do that on Zoom, but I don't know if David's
Kathy
got
will
it
be
posted.
asked to walk us through it later.
Okay. And we'll get Kathy to walk us through it. The next step was to take it from the police committee into the laws and claims committee, which we are doing today. And so that any ordinance that would come out of this would come through the laws and claims, which is proper. So I think at this point, I'd like to if Chief Walsh, is that pretty much how you, okay, so that, and I think Don, as chair, as a mayor, that's pretty much so that we're all together on where we're coming from.
That's fine with me.
Okay. So now I'm going to turn it back to the Laws Committee, Ms. Duke, and she can discuss on start the discussion about this piece of the ordinance, a proposed ordinance.
Thank you.
Proposed amendments.
That's right, proposed amendments. Let me ask Chief Walsh, and he and I had a brief conversation around this about to describe the concerns that has come into the police department, the complaints of any which have been placed. I am looking for factual data upon which we can reach some conclusions of fact or findings. And that's why I'm asking him, not to put him on the spot, but because it's critical that we act upon facts. Thank you.
The police department has received and does receive multiple complaints every year of junk vehicles and vehicles on property. We handle them on a case-by-case basis. What we're dealing with right now, a couple of the complaints that we deal with on a regular basis is that we have no way to get onto property to check VIN numbers, run license plates, because the vehicles are covered up, obscured, or in some way, shape, or form. So we need help to try and get us that access in some way, shape, or form.
Let me ask you a bit further. When you use the word vehicles, what are you referring to? May I ask? There are motorcycles, there are cars, there are RVs, there are golf carts.
Mostly what we deal with are cars.
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 Okay. That's good to know. Don, as mayor, and then David Lumsden as the village administrator, let me ask if you have received any complaints or have any additional information to add to what the chief has said.
I will confirm what the chief has said, that we have received multiple complaints about cars being parked on neighboring properties that the neighbors consider objectionable.
Anything in writing from either of you? Any of these complaints written, or are they verbals?
We have received them both verbal and in writing.
Yes.
But if we receive a verbal complaint, we will make note of it, and therefore it is in writing.
The same with the police department.
Thank you. And that's also important because we don't want a he said, she said situation and consider enacting important legislation or an ordinance based upon that. There should be some written record of these problems and complaints and concerns. David, as administrator for the village, can you add to what the chief and the mayor has said?
I cannot add, as both provided very comprehensive background on the situation. We have a combination of verbal and written complaints. And as the mayor has said, when we receive verbal complaints, they transform into written record when we receive calls or in-person visits. So we do have record of complaints.
Okay, at some point before this goes much further outside of the committee, outside of this meeting, can you follow up and provide council members with a summary data aggregate of the complaints over which period of time, so that we have some factual data to base actions upon?
May I ask, Madam Chairman, that we just put that on hold until we decide we're ready to send something to council from the committee?
I think that's what I just said.
I'm
But
sorry, I
you
didn't
said
hear
it,
that part then.
in a
If it's-
different way. That's fine. We're in accord. And what we are both saying is that before anything goes to council members and at least this committee and the police committee need to have some data, written data, and not just based upon oral recollections. Thank you. Councilmember Nancy Masinko and then Will Kreidler, would you care to comment upon what you're hearing, your perspectives on this.
Well, I'll hop in on it. I have heard anecdotal comments. I've not received anything in writing. I'm also a walker in this village, 2, 3, 4 miles a day. It's not unusual. And I've observed as a resident a number of homes across the village that have a number of cars that appear to be in, different stages of disrepair or operation and are littered in the backyard and are considered, in my mind, a nuisance. If I lived next door, I use that as the gating factor. If I lived next door, would I consider this a nuisance? And I would. And if it were in my backyard, I'd be calling the chief on that. So that's my experience with it.
Thank you. Well,
That's similar with mine. Would you, especially social media, the last few months, few weeks, we've heard a lot. Would you say it's less than 10 in Glendale that you've heard of, as far as residents or businesses?
Less than 10 complaints?
Yeah, no, less than 10 locations, less than 10 actual homes or businesses?
Yeah.
Okay.
so we're talking about a handful, really a handful.
Yes.
Yeah, thank you. And that's a good question. Thank you. So that's what we'll anticipate receiving more information on. Alan, do you want to add a comment on this?
No, I've had a number of verbal complaints socially, and all I can say is that we are starting a discussion on what constitutes abandoned, what constitutes junk, what constitutes actually the definitions of what we're looking at. What is a vehicle, which is a boat, or is it a, what have you. And the other thing that I caution people about is that we are governed by a constitution in this country that goes into illegal search and seizure, and it goes into these kind of problems that what seems like a relatively common sense ordinance type of a solution to these problems could actually be a bigger can of worms that may not have to be opened if there's some common sense attached to it. I have lived next to somebody who had a number of junk cars, and I could view them out my bedroom window, and that is very obtrusive to me. But at that point, though, he does have his rights also. So I think we need to go at this a little slow. I think we need to have a lot of discussions on the definitions that we're dealing with here. I think we have to have a lot of common sense type of things. I know that we've been looking at other neighborhoods and came up with some of the stuff that they do that I think is a little beyond what we need here in our village. And I think that, I see, I mean, we've got, 13 pages of an ordinance that we already have, which is under the health and sanitation clause of our city ordinance, our community ordinance. And of that, there's a few clauses in that garbage and rubbish paragraphs that have junk motor vehicles, have definitions for the junk motor vehicles. And I would like to either see Kathy or Don, if you talked with Kathy about these definitions and
Well, we're
things.
going to talk with her this afternoon and ask her to walk us through what is being presented to us.
Oh, I thought I was asked a question
Yeah.
by
Did
Mr.
you-
Holweller,
did
the
you-
chairman of the police committee.
Yeah, the police, in fact, you can tell us, because I didn't talk with Kathy, but you did. How did you direct her? I mean,
Good point. Good
We
question.
had asked you, the police committee asked you to have Kathy do this task.
Correct. And she and David did look at other jurisdictions that had statutes and ordinances in this area. And Kathy then went to work coming up with an ordinance that would work for us. She has had experience in other jurisdictions, so she didn't have to start from a completely blank page. And she has given us some her thoughts and the product of her work. And it's a difficult problem, as Alan has said, because we have we do have a Fourth Amendment that protects us from unreasonable searches and seizures, and the courts have been very strong in protecting homeowners against jurisdictions, governments that are going to intrude on their rights. So we have something to start with if and when it is the desire of this group to see it. And I believe most, if not all, of the members of the committees have received this document at this point.
Thank you, Don. Let me say that we have received it. We received it Tuesday afternoon. I, for one, have not gone over it in detail, which is something that I'm hopeful Kathy will walk us through this afternoon. I did glance at it, obviously, and I did notice there are a number of technical words, seem simple on the face of it, as Alan was saying, but yet have statutory meaning at the state level. I also had an opportunity, let me give you an example. The word vehicle is defined in Ohio code. The word junk is defined. The word abandoned is defined. There's definitely a difference in willful abandonment, so to speak, and unintentionally leaving something behind. There's a difference in terms of who gets notified and when. Notice to the local police department, notice to the owner, notice to the leasee or whomever is in possession or whomever is in control of the property. So these are very technical terms underlying this. And I've also had a chance to look at some jurisdictions, and I'm interested in hearing from Kathy on the jurisdictions that she has had a chance to look at, which have enacted local ordinances on abandoned or junk vehicles, so to speak. And what I see is a wide variety of local ordinance, some which are very simple and some which are lengthier than what's being presented to us. So the matter before us is simple on the face of it, as you said, Alan, but far from that. What really concerns me even more than the statutory wording is the impact upon neighbors. Someone complains about junk or abandoned vehicle on the neighbor's property. I think any one of us can imagine the impact upon you as an individual if that charge or claim or complaint or concern were expressed against you. It's the kind of thing that drives people apart rather than bring neighbors together. And so we need to be very careful in looking at what we are calling junk, abandoned vehicles, and how we, if at all, will authorize our police department or anyone else to go further than what the current law in Glendale allows. I've said enough, and I thank everyone for their input. Having said that, I'd like to turn to Kathy, our solicitor, if you will walk us through what you're presenting.
Thank you, Madam Duke. Can everybody hear me okay?
Yes.
Okay. Does everybody have a copy of this draft in front of them?
Okay. Yes.
Okay. So I think to start, it would be helpful to give a little context regarding where we're at and then where you want to go. And so to do so, I think first you probably want to turn to page 8 of the document that goes past what would be the new ordinance and is an excerpt from the zoning code that would also need to have a little bit of an amendment. Right now in your code, you don't have any mention of junk vehicles except for this piece in the zoning code that defines it per revised code 4513.63 and then gives you regulations regarding vehicles that would then be enforced within the zoning code per the same enforcement and appeal procedures that you're typically going to find in a zoning code with the 30 days and what have you. Junk vehicle regulation is something that, while mentioned in passing in most zoning codes, that's not really the key type of ordinance under which you would want to regulate that. The main reason being that the timing issue, a violation on a building that they have 30 days to correct or appeal is quite different than a junk vehicle that could conceivably should be moved very quickly. And it's just generally it's a property maintenance issue and should be treated as such. But to begin with this section also refers again to the 4513.63. And a lot of ordinances do this. I do think the Ohio Revised Code 4513.63 is good for some things, but it's actually inapplicable to junk vehicles the way that communities regulate or what they mean to regulate regarding junk vehicles. So 4513.63 gives you some of the points in the definition of junk vehicle that we'll go over here in a moment. But the key thing that makes just simply referring to that definition inappropriate is that 4513, I'm going to keep misquoting this, 4513.63A first starts off by saying, before it defines what a junk vehicle is, it says, to begin with, it's a vehicle left on a private property for 48 hours or longer. And this is the key point, without the permission of the person having the right to the possession of the property. So this is a very specific statutory provision that's actually meant to apply solely to a situation where you as the property owner have a vehicle on your property that then otherwise meets the definition that's shown below Section A, and you don't want it there. So under this section, the government has the right to come on your property that when you gave them permission to, and to take that vehicle away. And it's not considered to be running afoul of anything, or it's not a situation where someone lawfully parked on a parking lot or anything like that. So while this statute is a good starting point for the other points it makes regarding age, condition, fair market value, all that, we can't just simply refer to it because it's not applicable and doesn't come with the same Fourth Amendment considerations that we're operating under. So with respect to that, you will see, and I won't go over everything after this, but page 8 on just has some of the kind of things outside of the health and sanitation chapter that would have to be also changed to make everything consistent. So with that said, turning back to the first page, there were a couple sections. You'll see that chapter 93, health and sanitation. I copied and pasted the whole table of contents for that chapter, so you had some context to where this would fit in. This section obviously regulates a number of things, and one of the general provisions that it starts out with in 9302 that kind of then applies to everything in that chapter is nuisance and or hazard about property prohibited. And this section I just simply cleaned up to kind of match and help out with some of the other things going on within this section. And we can actually come back to that because that's all kind of general and would generally apply to that entire chapter. What we really want to do is go to page 3, junk motor vehicles. And as you could see, this is all underlined. This entire thing would be new. And I did, when I wrote this, I will say we've got a number of remedies in this chapter, everything from the fines to the any kind of injunctive relief to confiscating the vehicles and all of that. We put everything in there. It doesn't need to all be in there at the end of the day, but that's kind of our starting point. So when we start off with 9307A, junk motor vehicles, this is the part where I at least pulled from the Ohio Revised Code 4513.63, kind of the key characteristics that you would find on a junk motor vehicle within that statute. And of course, it leaves out the part where this is a vehicle that's only on your property when it's somebody else's. So that, again, we kept that all otherwise the same and pulled that language from the revised code. And then 9307B simply kind of is the statement. You know, this is a very long section, but everything after this is going to be procedure. 9307B is the clause that's telling you that junk vehicle we just defined, it's got to go if it's doing whatever it's doing within this time period. So then we move on to pretty much 9307C through the end of this section is all going to be all the procedure. And as Mr. Howeller had stated, this is very much a constitutional kind of hot button issue. And with Fourth Amendment constitutional issues come a lot of procedure in order to ensure that hopefully it's done in a way that can be defensible. So then we start off, we've got 9307C. This is simply a statement that would be a declaration that where a junk vehicle meets the definition under 07A, it is hereby declared a public nuisance. Now this 9307C, you kind of have to look carefully at it, but I will note in this section, it does two things. It addresses what we're talking about, which is junk vehicles on people's own property, but it also has a mention in passing that just generally any motor vehicles meeting this definition on any public or private land can be declared a nuisance. So this provision kind of takes it a little bit further just to cover any need of the village to declare junk vehicles that you otherwise find anywhere else in the village on public property to also be a nuisance. 9307D, enforcement authority of building commissioner and notices of violation. I will start with this section. We drafted a section that was very similar to this for the Evendale Property Maintenance Code. And that had to do with not specifically junk vehicles, but property maintenance. And there was a challenge to that in federal court, specifically on the Fourth Amendment issue. And at the trial court, we had one phrase in this regarding the right of entry and inspection that they challenged, and the trial court said that part was unconstitutional. So we then changed it to another phrase that had been upheld by the Sixth Circuit. And then the Sixth Circuit said that both the prior phrase and the one we had redrafted it to were both constitutional. And that was that. So for me, no need to reinvent the wheel when it comes to something as specific as right of entry and inspection and Fourth Amendment considerations. I thought it would be great to be carefully using, to the extent it's applicable, the procedure that we had there that was otherwise all upheld. So again, powers of the building commissioner, that's where we start off, just simply saying that the building commissioner has the authority. And you will see later in this packet, part of the sections I'm not going through, there's a place outside of this section that talks about the building commissioner generally. And we've noted in there that when we say building commissioner in the municipal code for Glendale, that also means his designees. So if this is a thing that's enacted, then he's the official person that's going to be enforcing it, but it's presumed that he can delegate to the police officers or to any other village official the same duty, the code enforcement officer, anybody like that. So this section declares the building commissioner, or by implication his designees, the right to enforce this chapter. Or I'm sorry.
Kathy,
Sure.
let me pause you for a moment because the version I'm looking at on page 2, is that what you're referring to? Section capital.
Page 4.
I'm sorry, go ahead.
What page are you on? What page are you?
Oh, on the bottom of page 3.
Okay, if you will look on page 2, paragraph C is in Charlie. I think a word may be missing or something. It's not clear before the word issue a notice. Who is issuing that notice within this paragraph?
Yeah, within the village causes or permitting. Yes, you're right. That should be building commissioner.
Okay, so that will be cleared up later. Please continue.
Okay. So turning then to the top of page 4, this is kind of, what we want to do, it's kind of twofold. You want to have the procedure written out step by step, because any turnover or anything with any village officials that enforce anything, you want to make sure that everybody is doing things the same way every time, and they're following the same thing from official to official, and from property to property. So the more detail you can put in the inspection and violation procedure, especially for Fourth Amendment sensitive issues, the better. And then also, and this was an issue with the Fourth Amendment challenge, and it usually is that while people have standing to sue villages on certain provisions that violate their constitutional rights as they are applied against them, there are issues like this where simply the existence of this as written on the books, if written wrong, can be something for which they have standing to bring about a Fourth Amendment constitutional challenge. So it's very important not even to just have a procedure in practice that is being done properly, but that it's spelled out that way, so that those who have the potential to have their Fourth Amendment rights potentially pressed back against via this junk vehicle issue, they're made aware of what their rights are, what they should expect, and all of that. So inspections.
Before you proceed, let me ask you, where is the definition of vehicle to which would apply in section 9302 and 9307?
Yeah, that's a good
I see
question.
a definition.
There are one of the things that I don't have in here. I've defined what a junk vehicle is, and then I've defined what a nuisance, I think the phrase blighted parcel. I added those two definitions because those to me were very kind of messy and should be very specific in the way that they're drafted. But then there could be any number of other phrases or words like vehicle that we need to add definitions for in this chapter. For me personally, when it comes to definitions outside of some of the very specific things, I find it better to have all of you read through it. And you said vehicle, which is one that should be defined, but otherwise kind of anything in here that seems to be a term of art that you as the reader are looking at and saying, I need to know, this to me isn't clear enough. We can and should put all of those definitions in the chapter, and those should be added.
Well, I think up front, the word vehicle does need to be clarified because it has a statutory definition in the Ohio Revised Code, which is deleted by reference in 93.02 and elsewhere in this proposed revision. So the word vehicle is a key word. Vehicle is going beyond a car, which is what the village has had problems with, to include RVs and other motorized cars and vehicles under the Ohio Revised Code. So we'll need a definition or clarity. No, not clarity. We'll need a statutory definition on the word vehicle. Otherwise, we're problematic. Thank you. Please continue. And I don't mean to keep interrupting you. I just want to be clear where we're going with this. Thanks.
No, that's fine. Anybody who has any thought, please jump in, because we want to make sure we're addressing it as I'm talking about it, if that's helpful. And to your point with RVs, we want to be careful to add not only motor vehicle, but non-motor vehicle, because obviously something like that, you know, I don't even know if it qualifies as a vehicle or if we would need to add language that says vehicles and recreational kind of craft to cover that. Anyway, so again, I won't walk through every single thing in here, but you can see looking at 3, 4, and 5 that we've kind of just given a very detailed step-by-step. Here are the ways in which you can gain right of entry. You have to show identification, how you give notice, and then most importantly is B, we've provided kind of very detailed, it has to be in writing, include the description of the property, you take photographs to the extent it's available, provide all of these things in the report. And then you have to include the correction order that says the responsible party has X amount of time to correct something or else appeal. And that's very, very important to make sure that it's very clear that somebody has a right to appeal, how they do it, and when they do it. And then also inform the party in that letter that they have, that the village, if you choose to include this as one of your remedies in the final version, inform the parties responsible of the village's right to file, to abate the violations and to file a lien. So that
I need to pause you one more time here. On page 3 in section 93.07B as in boy, we come upon, in the second line, we come upon the phrase, or any person otherwise having care or control of any premises within the village. Let me read the preceding words. No person in charge or control of any property within the village, whether as owner, that's clear, tenant, that's clear, occupant, maybe, lessee, or any person otherwise having care or control of any premises within the village. Care or control, what does that cover when, for instance, someone is away on vacation for the summer or for weeks and someone else is house sitting? The person may or may not be an occupant, but clearly, is that person perceived under this language as being having care or control? Who does care and control describe?
That's kind of a catch-all phrase that's meant to kind of envelope everything you see before it, the owner, tenant, occupant, lessee. If you're a code enforcement officer or a police officer and you're approaching a property and you see these vehicles and you think they meet the definition, and you need to determine to whom your violation notice is going to go to, and you need to have some probable cause that this is the right, you know, your evidentiary threshold for the right type of vehicle and the right type of individual. This is kind of the catch-all to allow that person. They may have no idea whether that person qualifies as a tenant. They don't have to see a lease. They don't have to go look up their ownership records even necessarily on the the auditor's site if it's owned by an LLC, but they control the LLC or trust or what have you. So this is the thing that basically says to the person, if there is evidence, 50-50 probable cause evidence that weighs in favor of that person is apparently the one that has the care or control of this premises, then I've met my burden by providing notice to that person. And that at least gets it to the point where you've appropriately issued the violation to the party. Now, if you've got a situation like you're saying where, there's a vehicle, it's a junk vehicle, it stays there, and it's an unusual situation where somebody seems to have care or control of the premises. They're there, they're on site, they seem to be doing something where they have control of it and should be there, and they turn out to be a visitor or something else. Then the issue becomes they get to appeal that, and that would become an evidentiary point of contention between the person against whom the violation is issued and the village. And so in these situations, and I think this is pretty customary, you may have a situation where you're aware of the fact you obviously can look up who owns the property and issue the violation to a couple parties, at least the entity or the person who owns the property on record, and then also to the individual who you have observed being on site, because obviously those are, frequently going to be two different people. And so if you issue it to everybody, then you've captured what appears to be everyone within that. And one thing that I wanted to put in here, and now I'm thinking I may not have done yet, generally in those situations, what's fair and legal to do is to provide a clause that says that where you've got multiple parties that bear the responsibility, they're all individually and severally liable for that violation, meaning that either they're both liable for it or one or the other is. It's not like a either or situation. So this provides the mechanism by which the enforcement officer can make certain observations on site. They don't have to go on a document chase trying to figure out, proving that this is an owner, tenant, occupant, or lessee. And then that gives them enough at least to say, I've met my burden to believe that this is an individual having care and control. We send it to the owner, we send it to the person having care and control, and per the ordinance, both of those should the idea that they are truly the person with care and control of the property, then that violation would be upheld against them. And if not, if there's an unusual situation where it's just kind of an oddball thing, then that burden is going to be on them to say, look, yes, there's junk vehicles on this property. The owner has violated it by allowing them, but I myself am off the hook for XYZ reason. And that's the due process, the procedural due process that is afforded to them by having it defined and then having the appeals procedure as well.
Kathy, I'd just like to ask one quick question here. I would kind of think that there's probably some litigation over this phrase, this catch-all phrase, as you call it, that has defined when it is applicable and when it's appropriate and how it should be applied appropriately. So assuming this is a phrase that crops up, in the Ohio Code from time to time, it's probably something we can assume has been, and maybe you can confirm this, Kathy, that the courts have kind of decided how this phrase should be interpreted and applied.
Yeah, this phrase is used very frequently within codes, not just for junk vehicles, but zoning and property maintenance and everything like that. I can certainly check if any published court decisions have specifically discussed this. Of course, there could be some that are unpublished and inaccessible.
Rather than checking under zoning provisions, could you check more narrowly under junk or abandoned vehicle provisions, and also look into any meaning that's been given to it under Ohio Revised Code 4513 .63, 4513.63 et sec, which we would be removing from this particular version of the proposed ordinance, and losing that case history. The other thing that could be checked is with local ordinances, local municipalities, and how they have crafted language narrowly or whatever. And I don't want to hold out any as an example. I understand you have experience, but I think here in the village of Glendale, we definitely would need something in writing that is clear, since a number of people are frequently traveling or away and have various people tending to their properties, and wondering what authority is being extended to that individual to have the police, not just a building inspector. We're talking about law enforcement, police officer come onto their property. And that could lead to a lot of other things. Thank you, Kathy.
Okay, I just want to make one other comment here that we do have to, make some concessions to the size of the village legal budget. And so I will want to work with Kathy on how much the type of research that she does in order to respond to these questions. I think you're absolutely right, Madam Chairman. You're entitled to answers, but I need to know whether it's going to dig us into a hole here. So,
well, if it digs us into a hole,
we'll let you know if there is a problem comes up, and then we can work it out.
It's not so much as letting me know; it is so much as putting forth a clear provision if this goes much further. I'm not personal with this at all. Kathy, if you'll continue on, please.
Thank you. So then on to page 5 is where we start with the methods of service. It gives kind of 3 scenarios where it's obvious the individual is there, is not there, et cetera. Unauthorized tampering is just a provision that's common that says where something is required to be posted, it can't just be ripped off and ignored. And then the modifications provision is the provision that gives the building commissioner's designated discretion that, okay, we've got whatever time period we put in this ordinance, but if there's some extenuating circumstances where they say we need to give this person 10 days or something, this gives them a little bit of authority to adjust that based on whatever set of circumstances might make that a reasonable kind of adjustment. And then after that, we've got the appeal procedures. Appeals can be done to a number of parties, but this one, I'm thinking that it would probably be appropriate to maybe have it done to your Board of Appeals. But that doesn't need to necessarily be the body that does it. But that's something that I think is kind of a talking point for my purposes is which is it council? Who is going to do the administrative hearing if there is an appeal from this ordinance? But that would be provided in here. And then 93.
Kathy,
Go ahead.
Kathy, if you could hold for a moment.
Kathy, this is Alan. On an appeal, is there a time limit for appeal?
Yes, and one of the things I wanted to talk about is you'll see throughout this section that there's this time to conform and time to appeal, and I've got it as 48 hours, 1 week, whatever. My recommendation is that you want to have the time period, the standardized time period to comply, and the appeal period be the same. Because, and I would probably recommend 48 hours is probably cutting in a little close, maybe a 1 week period, at least for a first violation within a calendar year. And that way, the issue is that you don't want to have a 30-day appeal period, because if you tell the person that they need to remove the car in a week, and then 10 days go by and you want to exercise your rights as the village to exact remedies, whether it's removal or whatever, and then they turn around and appeal 30 days later, and then the appeal overturns the ruling, well, then what do you do? So this is a mechanism where you've got the car, it's parked, you tell them remove it in a week or appeal. And if they don't appeal, then you can just proceed with all of your remedies however you see appropriate. And if they do appeal, that would effectively place that enforcement on hold until they go through their appeal procedure. But I see a lot in codes where the appeal procedure and the enforcement aren't matching, at least for that initial violation, and it gets really dicey with, well, do we really want us to proceed, or do, you know? So that's what I recommend, but I don't have a set time written down yet. It just, some of that kind of depends on the desire of the village.
Thank you.
You're welcome. So again, 9307F kind of says what I just stated, where if you fail to either comply with the notice or to appeal the notice, then your situation is conclusively presumed to be a junk motor vehicle and a public nuisance, and then the village is essentially going to proceed to abate the nuisance, or has the authority to abate the nuisance if they so desire. And then the final part to that section is this 9307G, enforcement and penalties. And again, this has the imposition of penalties is found in 9399, which is kind of the penalties that apply to this whole chapter, and they're on the next page talking about $100 fines, separate offense shall be deemed committed each day. And we've added, Dick Weber recommended adding this language that in the case of junk vehicles, each day and each individual vehicle constitutes a separate offense. And then also the idea of the fines in section B. So that's your first thing you're working with, are the fines and the determination of what constitutes each individual offense. The second provision has to do with removal and disposal of junk motor vehicles. This, again, it's a remedy that's available, but it's kind of up to the village's preference as to whether you want to include this as a remedy in the chapter. Obviously, kind of filing, or, you know, pretty much filing any sort of, to be able to file a lien at all, it would have to be based on having done something that the village incurred costs to abate. So really 2 and 3 go hand in hand. Do you want to provide a mechanism in your code that allows the police officers to then direct those vehicles to be removed? And it refers to the statutory provisions that are customary in this sort of situation regarding the disposal of those vehicles. And again,
and
Kathy, if you could hold for a moment.
on the 93.7G, where we're just talking about the removal, is the term a junk motor vehicle too specific? Because I mean, we have in the other parts of this, we've talked about boats and RVs and trailers and that kind of stuff. Should we not find a different term instead of junk motor vehicles? Because if it doesn't have a motor, it's
Right.
not a motor vehicle.
Yeah, and I think that's one of the things that needs work, is if we define vehicle, or even take it a little further than a vehicle and say vehicle and recreational craft, and kind of define all of that, then one of the things we need to do if we do that is to go back through every provision we've got here and make sure it's got whatever term or terms that we use, so that that's all consistent.
Sounds good. Thank you.
You're welcome. And then 3, again, is just, something is a remedy that the village already has and can exercise regarding building and property maintenance code issues. And that is, if you do choose to abate a nuisance, that the village abates the nuisance, you're obviously going to incur some costs, in which case you can follow the procedures to file the tax lien with the county. And then 9308 is its own section.
Before you go into 9308, this is Marilyn again. If you could look back on page 5, 9307F as in Frank.
Okay.
There is a phrase here that I'd like to have clarified. third line, conclusively presumed, namely if the recipient of the notice fails to comply or appeal in writing, the vehicles shall be conclusively presumed, close quote, to be junk motor vehicles. What's the impact of being conclusively presumed? Does that mean that it is not, the question of whether or not it's junk is non-reviewable or appealable, or the question of whether or not the car has in fact been abandoned is non-reviewable or appealable? What is, I'm just raising this question right now. Conclusively presumed carries a lot of impact, especially on appeal.
Right, and that's a good question. That's in there kind of to clarify procedural law that is already the case, whether we say it or not. So if we take that out, what I'm going to explain applies anyway. So we kind of put it in there to give the reader, the property owner, extra kind of notice of what their rights are. And what it really means legally is that when you do have an administrative violation in a scenario like this, and it's issued against you, and you get the notice and it says you've got a junk vehicle and it's been there for too long and it needs to go, and you say, well, you know what, I don't agree, I don't believe this is a junk vehicle, so I'm just going to ignore it. And the way the Ohio law goes is that that's an evidentiary dispute that you have with the village, and your only way to get out of it is to not say, well, I ignored that and I'm going to argue about it after the fact. You have that appeal period. So if you don't appeal within the period, you've lost your chance to contest that point. And that's already going to be the case. If you don't appeal something, then your administrative remedy is cut off. And so this makes it clear to the reader that if you don't do this, your chance to contest whether that's a junk motor vehicle and a nuisance is done. And so disagreeing with it isn't going to be something that you can quibble over later. And because the legal requirements in an administrative process already but they've already definitely imposed that obligation on the individual against whom a violation notice is issued. This kind of language to me is there for the purpose of kind of giving a little bit more information to a layperson who's not going to likely be aware of that fact.
You were on 93.08 definitions on page 6.
Okay, so with this whole chapter, since we're drafting all this, and we've got to be able to keep in mind that we're within a whole chapter and we need everything to work together and be consistent and all that. And on the first page, we start off with this 9302 nuisance and hazard, so that just to kind of clarify generally for the whole chapter who is the responsible party, and throw in the junk vehicle stuff, and then also just kind of be clear about any kind of nuisance stuff that's going on in this chapter. And one of the things that was in here, and let me find it, I'm trying to find the exact phrase, because this was one Dick Weber found. Public nuisance. Okay, so if you go on to page 2 at the top, when it's going on about the accumulation of trash, junk motor vehicles, and all the stuff that this whole chapter regulates, it says that all of that shall be considered a, quote, public nuisance when such condition creates a blighted parcel. And this is one of those examples of where I'm drafting and then the other, a third party gets a hold of it and says, wait a minute, we need this defined. And Dick Weber said, you need to define what the heck blighted parcel means. And that's definitely the case. And so what we did here, anytime you can use some Ohio Revised Code language that does apply and doesn't undermine your purposes, we like to do that. So, and I don't have it written down, although I can find it. I pulled the blighted parcel language from a particular code provision in the Ohio Revised Code, and I will make a note to have that citation so you all have it. This is, again, the 9308A just defines blighted parcel for the purpose of the entire chapter as being a parcel with, and you can see a parcel has one or more of the following conditions, or number two, a parcel has two or more of the following conditions. And to test the strength of this definition for the purposes of this entire chapter 93 with respect to weeds and vehicles and all that, I would urge all of you to kind of look through it and imagine a property that you might see that's violating anything in this chapter. And, do you think, okay, that will be, yes, I could see that in that case, this parcel that I'm envisioning that's violating the weeds or the vehicle, I could see how they meet at least two of section 2, subsection 2. So that's just, again, it's just a definition we've added for the blighted parcel issue. And that definition supports the phrase blighted parcel, and blighted parcel supports the phrase nuisance. I guess, let me get the phrase right. The phrase public nuisance. And that's pretty much it. You can go through the zoning code stuff is changed just to the extent necessary so that everything makes sense and doesn't conflict. But it's a starting point. There should be some things added, and there's a lot less to do, but I think it's we've got a good thing to start with.
Questions or comments for Kathy? I know we've been peppering her while she's been going through this. Yes, do you have a question or comment? Go to the mic.
Jeff, could you go up the mic?
My name is Jeff Baysmith, and I live at 10 Lake Avenue in Glendale. I may have raised my hand a moment or two early. My questions pertain to the revisions in the village code, starting on page 8. So perhaps we should wait until you address that.
Kathy, were you going to walk us through chapter 93 related to section 154.26, the parking regulations in the village of Glendale on page 8?
Yeah, this 154.26 is in the zoning code outside of chapter 93. So this section we simply have included because we want to make sure that we've uniformly defined junk vehicles throughout your entire municipal code. So this is just your zoning stuff. It's been there. I have it unchanged because zoning, this whole thing, I put the whole section in there for you, but this whole section, it serves a purpose in the context of zoning, but it's not the most effective place to actually enforce junk vehicle violations. So it's there, and I don't recommend taking any of it out or doing anything other than changing the junk motor vehicle definition and then taking out the reference to 451363.
Jeff, would you care to
Yes,
raise your comment or question?
My request or suggestion would be to take a look at the various segments. And I'm speaking on page 9 at this point under paragraph C. However, the definition of junk automobiles unfolds eventually, as I understand it. If it's licensed, very often it's very difficult to call it junk as long as it's licensed. That's my understanding, but it may not be accurate. More importantly, my concern is that if it is considered to be not junk and remain on a property, that the description, for example, in paragraph C, item 2, subparagraph 2, it talks about the items being adequately concealed. And that's like telling my grandkids to adequately wash the dishes. Does that mean wash them well, or does that mean adequately? And the problem is that when these junk automobiles or items are still visible and still able to remain on the property, adequately is subjective. And I would like to suggest that in that paragraph and in the subsequent paragraphs that you consider saying concealed, not adequately concealed, because in some cases, automobiles are temporarily hidden by overgrown vegetation, that weed that we are suffering with, a canopy weed that crawls over the vegetation and everything underneath it dies. It hides vehicles until fall. And then when the leaves fall off, the vehicles are still there. And so each of the paragraphs, and I mentioned C2, as you look at the other paragraphs, each of them say adequately. And I would like to suggest you consider making it concealed, not just adequately, because adequately is too subjective. Thank you.
Thank you.
I apologize. I didn't realize we were going to discuss this. I should have been at the previous meeting.
Well, this is the meeting. This is the first meeting where we're discussing this. Thanks. Any other questions or comments to Kathy before we move on with this proposal, with the proposed language? Kathy, do you want to continue?
Sure. To address his comment, I think there are a couple things in the zoning code. Once the definition and scope of vehicle in Chapter 93 is ironed out, we do need to go revisit this Section 154 in the zoning code and make sure that the way the words are used and the phrases and how it all kind of, again, even if they're two separate independently operating ordinances, we need to make sure everything kind of has the same wording and definition and doesn't conflict or confuse people about what their rights are. And kind of the phrase that I usually see that should definitely replace adequately concealed is that simply, if you've got one of these, you've got to have it, quote, wholly within an enclosed building. That way, you can put it in a garage, but
Go ahead.
Could you, Kath, could you just repeat that again? Replace with, what was the phrase?
enclosed wholly, or I'm sorry, parked wholly within an enclosed building or structure.
Got it.
And yeah, anywhere where you've got the word adequately, you want to take out in any local regulations, any words like that just make things open to interpretation and subjectivity. They should go away. So kind of the two kind of key things for the moment are where there's such a vehicle located within the village, it would be automatically observed to be in violation if it meets the definition as provided on the top of Section 3. Dick Weber had reviewed this and he was okay with it, but at the same time, we're all just one person each. And if there are other people that are looking at this and thinking about the way this is drafted and the way you would define a vehicle and any kind of ideas of how you think this may be confusing or inadequate, we can certainly work on expanding that. And then second, how long do you want to give property owners or the parties that are issued these violations? How much time do you want them to have to either comply or appeal? Again, my recommendation, I think, is a week. Dick Weber had said 48 hours, but I think that's kind of short. That's in the statute, the 4513. But again, that statute is about letting the person who actually does own the property ask the government to remove someone else's car. So that, you don't have the same Fourth Amendment issue there. So it's very short. Here, you've got to take more into account to adequately cover individuals, both their due process rights and their property rights. So you need to give enough time where if they do want to appeal and for some reason they feel they need to mail it, it gives them a few days. Kind of just things like that. You don't want to make it so long that you've got vehicles that come in and you kind of start to evade enforcement and become problem vehicles on an ongoing basis, but you also don't want to make it too short where we're starting to toe the line on the constitutionality considerations. So I guess that's, with those two things balanced, I think 1 week would probably be okay. But again, that's going to be up to all of you.
Okay. Is that it, Kathy?
Yeah, I think that's it for now, unless you have any other questions.
Yeah, okay, let me ask the committee members for your comments, your thoughts. Nancy, Will?
That's an awful lot of information in an hour and a half.
I agree.
I think I need to study this a little bit before
I
we
agree.
would do anything else. I think that it's a necessary thing that we have in our ordinances, but I want to make sure that, and I think Kathy's done a wonderful job of
Alan,
back and
speak
forth.
up.
But can't hear me?
Right.
Okay. Thank you, Kathy. That's a good job. Appreciate that.
Nancy?
So I would propose let's continue to look at this. Let's study this for a while. Kathy has some additional work, and there's the definitions that are outstanding. So it seems as though we study this with the hope of discussing perhaps a final draft, or certainly a next draft at the next meeting. But I'm wondering, with that in mind, could we establish a process timeline so that we look toward, if there is a recommended ordinance for council, that we look toward where that might hit? Is it not going to be July? Is it going to be August?
No.
Because I work better with a deadline, and that's
I understand.
my thought.
My thoughts are similar, Nancy, quite frankly. I think, and Alan, this is quite a bit to digest, and I think it warrants our time. I'm willing to call a meeting in July. I was going to say September. I'm willing to call another meeting of the Laws Committee in July to focus on this again. Also, I think now that we have the draft, we're likely to hear from hopefully more residents as well as more members of council. And I would definitely circulate this draft to other council members who are not on this committee, because this is a bit much, regardless of the action taken by this committee. Having said that, I will I'll work online to set up a meeting in July, after July 4th.
I would hope that perhaps before then, that we could get Kathy a list of the follow-up issues that have been identified at this meeting.
Yeah.
And I've been trying to keep a list, but I'm sure I'm missing a couple. Madam Chair, if you would like to circulate a list, I'll be happy to add to it. Or if you'd like me to circulate a list, I'll be happy to have you add to it.
Well, I think any one of us can put forth things for her to address, recognizing the autonomy of each council member. I certainly would like to have every matter I put forth addressed in some way, so I'll be glad to circulate it to you and other council members.
Thank
so
you.
that we're not redundant in that regard.
Perfect.
But I do want them addressed. Having said that, we'll move on to the next item on our agenda. And I think we can go through the rest of this agenda in short stead. Nancy, I understand from communications that you wanted to speak with our police department on policies regarding the use of force.
I do. However, we're heading into more than an hour and a half on this meeting, and this is a subject that I believe takes a little more time than just 5-10 minutes. I'd love the chief to talk about this. I think it's an important issue here. It's certainly important within the community, and so it deserves a little bit more time. Would there be any opposition to postponing this? Either chair.
Yeah, let me ask the chief if he would respond to this on the thing about where description of state of Ohio, Hamilton County, the training, the regard of chokehold, and that. Yeah, give us a quick synopsis of what you're doing, proactive.
Hang on a second. In response to Nancy's question, she asked if this could be deferred and brought up in the police committee meeting.
Well,
what she was talking about.
Since I'm the chairman, I'm going to override her and let the chiefs talk for just a few minutes. And if that's okay.
I think we're talking two different things. I was talking about point number 3, the review of the policy on the use of force.
I see that, but we don't have. That's why I wanted him to talk on. What is our policy?
Well, but my question is,
you want to postpone that?
Because I think it needs more time than we can give it today.
And that's okay with me, if that's okay with you.
Yes, sir.
Okay.
Great, thank you.
So can I schedule another police committee meeting right now?
Not now.
Why not?
Because we're going to move on with this agenda right now. And then you can schedule your meeting. If that's okay with you.
The chairman of the
It's good to have friends, isn't it?
Okay, go ahead.
In the same token, I will ask that we defer conversation on what is under administrative matters, and that is for the chief to speak with us about training from the state or by the state that's being provided on the use of deadly force and implicit bias. And this comes to light from an article in the news, of course, that local jurisdictions have reported such trainings. And I have shared this news article with the chief. I'll leave it with him and he can look into it. That article was written before he became chief, so I'll give him the benefit of the doubt. But we would like to hear next time the police committee meets, or the laws committee meet.
Can do that.
Thank you. Also, we would like to hear what the Glendale Police Department is doing in regards to the Ohio Collaborative Community Police Advisory Board. This question came up in late October or December, again, before you became chief. And many of the jurisdictions in Hamilton County are listed. Glendale's police department is not. So I'll leave that with you and we can hear further on that later. Alan, you wanted to, and this is the last item on the agenda this afternoon. Alan, you wanted to speak about what kind of coverage, benefit,
right,
that a police department, a police officer has when he is seriously injured in the line of duty.
Correct. I watched a podcast called Honoring the Badge. It was on the Fox Nation. And there was a police officer there who was wounded 6 times in the line of duty in Atlanta, Georgia. And when he realized after he was in the hospital with paralyzing injuries that all he had to fall back on was his workman's compensation. And I asked the chief what we have in Glendale, and the answer was workman's compensation, plus the helping hands of the Ohio Police, FOP. Would you touch on that? What do we have?
Right now, it would fall back on workman's comp. There's an organization called the Ohio Shield, which is a group out of Hamilton County that raise money and give money to families of officers that have been hurt or killed in the line of duty, and try and help as much as they can there, pay bills and mortgages and things like that. The FOP has some benefits if you belong to the FOP, but other than that, it pretty much falls back on workman's comp. Mm-hmm. Not sure.
Mr. Chairman?
Yeah.
Yes.
You mentioned this to me, I think, the other night, and I did take it up with David. I think I'm going to pass the buck to David on this one because he does have some additional information, I think.
Okay. Well, is David still on?
I am.
Great. David, can we hear from you?
Speak up a little bit, David.
Absolutely. Okay, 1 second. All right, give that a shot, see if that's a little bit better. So I did speak with the mayor. I spoke with Chief Walsh as well. And unfortunately, we have had some instances where officers have had situations where they've had to rely on these types of time off, or call it salary replacement, when they can't work. And workman's compensation is the first checkpoint, so to speak, for their claims. If they are injured in the line of duty or are involved in an accident in the line of duty, something that impacts their ability to fully do their job, they have the ability to rely on workers' compensation. They also have the ability to rely on the sick time and other leave balances that the village provides them. It is important to point out that during the time that they are on workers' compensation or drawing from their available leave balances, that their village benefits are not interrupted. So the health insurance benefits, dental, vision, those benefits are not interrupted. The village does also offer life insurance policies for employees, and several employees take up supplemental policies as well that are automatically deducted. So we do have, really as best we can offer, because of our size and because of the cost of providing some of these programs, what's best for our officers. And those programs have proved to be successful in the unfortunate circumstances when we've had to rely on them, or rather when our officers have had to rely on them.
Okay, and I think this is something that the chief and his organization, his department, need to advise us on, because is it adequate? Workman's comp is something that is almost just a stopgap if you're seriously injured or in the line of duty. And I think I will leave that up to Chief, if you would get back to us on just see if people think that's adequate, because I think I know that we've self-insured our factory for decades, and we actually have a different policy for dismemberment and death in there, and it costs something, but it's not outrageous, and it relieves the burden of our family protecting our employees. And I think we need to look at that from a standpoint of what we do here and how we protect this village. Okay.
Thank you. Thank you, Chief. One thing comes to my mind is long-term care, and whether or not police officers in the state of Ohio have access to a long-term care plan that is open to them as officers. I don't know. I think our village is too small to offer that kind of a benefit, but perhaps on an aggregate basis, it could be. Thank you. Is there a motion to adjourn?
So moved.
Second, and since that came from the two people on the police committee, is that satisfactory?
Absolutely.
Thank you. We are adjourned. Thank you.
All right, and I will get with you.